please let us know. Please either let the bailiff or us know. And if it's not something that we want to talk about in front of everybody else, that's okay, because we can talk to you afterwards, in front of the judge and just in a private way. Just remember that there's no wrong answers here. Oh, again, we're just trying to get to know you. I want to go through a list of potential witnesses and see if anybody knows somebody that is potentially going to be a witness. Deputy Garrett Burdine, Deputy Robert Bailey, Deputy Desmond Jimmies, Yu Lin, the nurse, and Cheryl Scudler. And what about anybody you think they know me, know Mr. Boyd, Mr. Crenshaw, Mr. Bailey, Mr. Buxton, or Judge Holmes? Wow, okay. Does anybody have any particularly strong feelings about law enforcement? Maybe any negative experiences with law enforcement? Okay. I want to talk a little bit about the law when it comes to DWI. So DWI stands for driving while intoxicated. Let's start over here. Ms. Lemaire, do you believe that it's important to have laws against driving while intoxicated?
Yeah,
And why is that?
because of the accident. You're not capable of making decisions.
And what about you, Ms. Alfred?
Yes, I believe that, the DWI, there should be laws, because, I mean, there's things that happen behind the wheel or not even at a party, or anything that cause so much danger and so many things can happen. And they do need laws.
Thank you for that. What sort of protection would a DWI law prevent? Ms. Rocio?
Well, actually, it would prevent people from going out and getting drunk and getting behind the wheel and hurting people.
Hurting people, yes, ma'am. Miss James, what happens if a cop thinks that you're intoxicated?
I mean, I assume that they would want you to step out of the car and give you a breathalyzer or some kind of coordination test or something.
And Ms. Clark, what do you think would happen after that?
Their judgment call as to impairment, and then we'll go from there.
So the law, when it comes to DWI, says a person commits an offense if the person is intoxicated while operating a motor vehicle in a public place. And it is my job as the prosecutor to prove those elements within the law to the jury. Now, the person has to be intoxicated, right? The person has to operate a motor vehicle, and they have to be in a public place. Those are the three elements that it's required that I meet. I want to talk a little bit about what it means to operate a motor vehicle. Mr. Pitzer, is operating a motor vehicle, in your opinion, only limited to actually having a car and driving down the street?
No. You gotta know where you're going, watch everything. I used to drive semis.
Okay,
Different,
okay.
a lot more involved.
Okay. What about Miss Reed? Do you believe that operating a motor vehicle is broader than just strictly driving?
Personally, I say, I don't think the definition operating, just getting in it. Is that what you're asking?
Being in the car with it,
With it moving? That's what I think. When I think of operating, you being in the car and it's just moving, that's what.
okay. Would it surprise you to learn that operating a motor vehicle under Texas law certainly means driving, but it also means to be in physical control of the vehicle? Do you believe that you could follow the law, based on the facts and, come to a fair and objective decision?
Julie, I'm sorry, which juror number is that? I can't tell by my-
Number
Is that Ms.
7.
Ronquillo?
Ms. Reed. number
Oh,
7.
Ms. Reed, okay, thank you.
And, Mr. Ronquillo, do you believe that you could follow the law, based on what I just, mentioned to you, that maybe operating a motor vehicle isn't strictly just putting the car in drive and pressing the accelerator? And Ms. Wall, do you believe that you could, follow the law in this case, apply the facts, and come to a decision, based on strictly the law?
Yes.
Okay. Let's talk a little bit about what it means to be intoxicated. Is there anybody here that might believe that you have to be drunk to be intoxicated? Does anybody believe that you can be intoxicated before you're drunk? I see you shaking your head, Ms. Sims. Can you share a little bit about what that means?
I mean, any kind of alcohol in your system would mean that you would be intoxicated. Your weight also has to do with the factor of it. So somebody bigger can have one drink, but versus me having one drink, I would be intoxicated like the other person. But we would still have the same blood alcohol.
Okay. What about you, Ms. Watkins? Do you believe you can be intoxicated before you're drunk?
Yes. I don't know, I've never thought to define it so separately. But I mean, yes, I think about looking at the screen, yes, you can be intoxicated and not stumble and drunk. Maybe. Intoxicated is drunk in my mind.
Let's look at Title 10, Section 49.01. It gives the actual definition for intoxication. And it says intoxicated means not having the normal use of mental or physical faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more of those substances, or any other substance in the body, or having an alcohol concentration of 0.08 or more. Let's see. Ms. Baptiste, would you be able to look at the evidence of a traffic stop and hear about the behavior of the defendant, but convict them without any blood or breath evidence? Okay. And why is that?
You would have to have some resources if they were intoxicated and what was in there, what they were drinking. You can't just go and judge on your own. You just can't assume that they was intoxicated. You have to have some kind of clarification.
Okay. And does anyone agree with Ms. Baptiste that without any sort of scientific evidence to back it up, that you could not find someone guilty of DWI? Okay, Mr. Knott, can you talk a little bit about that?
Was there any other tests performed?
I'm sorry?
Were there any other tests performed? Or does anybody that arrested him know the person personally? If you can't tell what type of person person who was or she was before they were arrested for being intoxicated. I don't think you can make a judgment call to arrest somebody based off of, there would have to be some.
And Ms. Walker?
My concern would be in this medical field, there are other types of situations where somebody may show symptoms and look like they're drunk or intoxicated, and they may be diabetic, have low blood sugar. They may have a neurological issue like Rett syndrome or something like that, or muscular dystrophy or sclerosis. There needs to be some kind of test, even if the test is, you can't just say, I'm gonna do, for example, have them do the balance test and stuff. And there needs to be more now. If there's evidence showing this person was drinking or something from a bar, you had other evidence, that may be part of it too. But just to say, okay, you look like you're drinking and I have no other evidence, I can work with that.
So intoxication, can, be anywhere on the journey. Anywhere on that slide, or I should say this, 0.08, the level of blood alcohol concentration that the law says is the limit, can fall anywhere on that spectrum, and it depends on certain things. Or we've all seen that person that's like a tank, and they can just put it away, and it's like, they seem completely fine. And then we all know a lightweight, right, who has half a glass of wine. That's my mom. She has half a glass of wine at dinner, and, she's feeling buzzed, right? And she's not a 0.08 in her BAC, but you know what? If she's lost her normal mental and physical faculties, she would be considered intoxicated under the law. Ms. Parker, do you think that you would be able to follow the law in this case, applying strictly the law to the facts, and come to a fair and objective decision?
Yes, I can follow the law, but I would have to say that, I agree with the gentleman here, and the lady on the internet, that I would like some more tests to prove to be sure.
Okay, so you would need some scientific evidence to back it up, rather than just, maybe a conversation with a police officer.
It really depends on the behavior also, Well, because I don't know, some people may be a jerk,
So the use of, or normal use of mental or physical faculties, so physical faculties would include ability to balance, walking in a straight line, not stumbling, dexterity. We've all seen that person that's stumbling around because they've had too much to drink. Maybe they're slurring their words. We've all seen somebody maybe at a party, at a bar, a restaurant, or at some sort of get together. And you've seen that person, and you didn't necessarily need a scientific test to understand that they were intoxicated, right? Let's look at the mental faculties as well. Following directions, knowledge of alphabet, judgment.
Ms. Maxey, you have 5 more minutes.
Okay, thank you, Your Honor. Concentration, forming complete sentences. The loss of any of those physical or mental faculties would be intoxication under the law. The evidence is like a puzzle. And as we go through, I'm going to put together pieces of the puzzle. And some will be direct evidence, maybe video. And some might be circumstantial evidence, evidence that maybe was there, but nobody directly saw it, right? those coming together are gonna form the picture of what happened. And even though I might not have every single piece of the puzzle, you're gonna be able to see what the picture is. The burden of proof in this case is that we have to prove beyond a reasonable doubt, not a preponderance of the evidence, which is just right over 50%. Not clear and convincing evidence, which is the standard that family courts use. Beyond a reasonable doubt. I want to encourage you that that doesn't mean you have to leave your common sense at the door. It means you need to employ your common sense. We're not saying that you can't have any doubt. It's not beyond all doubt. Is that doubt reasonable? And that's the standard that we have. Is there anyone that has any reason that you can't serve or find someone guilty of a crime for any religious reason or any personal reason? And if you want to speak about it privately, we can. Okay, well, I want to thank you for your time. Thank you for your attention. And appreciate it very much.
Crenshaw, you may proceed.
Thank you. Right. Well, good afternoon, and I'm sorry we're now starting at 4 o'clock. Please know that we've all been in here working and haven't been in here drinking coffee or talking about baseball game or anything like that. I'm sorry that we're here this late in the afternoon, and I kind of feel like it's so late. You all might go to sleep. The good news is I have a hearing impairment, and I'm usually accused of being too loud. So court reporters love me, but people that don't like people that talk loud usually do not. So I apologize in advance. My name is Corey Crenshaw, as the judge introduced me earlier. I used to be the district attorney, and then I was actually the judge right here in this courtroom. And in 2016, after 12 years of public service, I decided to stop putting folks in jail and start letting them out. And now I am honored here today to represent Clavon Buxton in this DWI trial. Clavon, stand up. I know we asked this before. Have a seat, sir. Thank you. Does anyone here know Mr. Buxton? Mr. Buxton is a police officer in Port Arthur, Texas. Is there any chance, now that you know that he's a police officer, maybe you got a ticket from him back in the day or something, and that was an unpleasant experience? Anyone here know Mr. Buxton? No one? All right. Does anyone here know me or Mr. Jansen Bailey, the other attorney representing Mr. Buxton? Ms. Clark, you do know me. Yes, you know of me. Thank you very much.
I know Heather very well.
Wonderful, my amazing cousin. Anything about knowing Heather or knowing of me or maybe work we've done in the community? I know you are the director for the guest house at St. Elizabeth, and I do work at the guest house at Baptist, even though we're rival hospitals. Anything about that would
We
make?
still work together.
Yes, we do.
We serve.
So no one here knows me or Mr. Bailey. Correct. And I know that earlier Ms. Maxey asked if anybody knew her or Mr. Boyd, but does anyone know anyone in the DA's office? The Jefferson County District Attorney's Office? Yes, sir. Mr. Nod. Who do you know in the DA's office?
Her first name is Tatiana.
Tatiana Zalesniak. Yes. Fellow prosecutor. Anything about knowing Tatiana that would make you unable to be fair to both sides?
Yeah.
Great. Thank you, sir. Yes, ma'am.
I don't know if I know. I don't know if he works there. His last name's Crosby.
Crosby? Okay. And you think he works in the DA's office?
Maybe.
Okay, no problem. Anything about, and I don't know about Crosby in the DA's office, but anything about if you did know him and he did work in the DA's office, anything about that would make you unable to be fair? Great. And I think sometimes because of TV, people think that trials are a battle between the lawyers. They think, that Miss Maxey and I are going to be at each other's throats this entire process. I can assure you that that will not be the case. Miss Maxey is a wonderful young attorney, and Mr. Boyd here used to work in the Jasper County DA's office, and I had some cases with him over there, and I'm happy to say we get along extremely well. So if you think that this is going to be a knockdown, drag-out fight between the attorneys, you're going to be sorely disappointed. This is a trial that we want to be sure our jurors can be fair. And that really right now is the ultimate question. Because you all are probably great, reasonable people, and there may be other juries that you would be great to serve on. But for this particular case, with Mr. Buxton and with a DWI as the allegation, the question is this a good case for you to be a juror on? And I turn first to juror number 1 in the hot seat, Ms. Lemaire. Do you in your heart of hearts believe that this would be a good case for you to be a juror on?
Sure.
And I noticed in your questionnaire, you actually said that you would be unwilling to serve because of a relative that was injured in a DWI
I
accident.
did have a cousin
Okay.
that was injured. And
Okay. And so do you think, even though you're, and I'm very sorry to hear that about your cousin, can you put that out of your mind and continue to serve in this case and be fair?
try.
You could try, and I hate to be difficult, but I've certainly been accused of it before. I need to know 100% in your heart of hearts, can you be fair? Is this a good case for you to serve as a juror, knowing what happened to your cousin? That's fine. I understand. I won't go any further. And if anyone has anything, maybe an emotional situation or something that they really don't want to talk about in front of the group, I certainly understand that. I'm not trying to pry, but the law does require us to be sure that you 100% can be fair. So if you do have something you want to talk about, just raise your hand and we can do that afterwards. I believe there was another juror, juror number 4, Mrs. James.
Yes.
You were actually injured by an intoxicated
I
driver.
was hit head-on by a drunk driver my senior year of high school. Both my legs were crushed. And the law in the 80s at the time was different. There was no 3 strikes you're out or any of that. It did take a while to put that behind me, but I feel like that ended up being just such an eye-opening experience for me.
Certainly.
I didn't, it led me down different paths in my life that I wouldn't have gone down had that not happened. So
Completely understood. So the negligence and criminality of an intoxicated driver changed your life forever.
it did. I'm a, silver lining kind of person, I guess. So I mean, yes, it was bad, but I lived through it. I'm walking, which we didn't know that was gonna happen or not for a while. I don't know. It did change my life for the better eventually. It just led me down some paths
Wonderful to hear. Do you think in your heart of hearts, knowing what happened to you when you were in high school, that this is a good case for you to be a juror on?
I believe so, yes.
Okay. You're telling me that you can put what happened with you possibly not being able to walk for the rest of your life out of your mind and continue to serve in this case?
I feel that I can because I feel like I have.
Okay.
Definitely the first 5 or 10 years, I probably couldn't have done this.
If you were accused of DWI, would you want to have a juror like you on your case?
Well, I know me and I'm pretty open-minded and fair and logical, I guess. But I know that most people aren't that way. So that's a tricky one to answer. Like, I feel like I could be fair and impartial. Being a teacher, I've had to be that way with every student, no matter their background or what they're coming
What
to.
grade?
I am 5th grade this year, but I taught middle school most of my career. And children that are coming to me that are immigrants don't speak English. So there's a lot of kids coming that.
All right.
Yeah.
Great. All right. Someone else here had an injury. Miss Reed.
I'll say my answer is no, in my heart of hearts.
Is no? Understood. I appreciate you telling us that. And that was due to an accident involving a drunk driver?
Or believe.
Right, you're not sure, but you assume that. I understand.
It was just recent, so that's fine.
Oh,
Yeah.
I'm sorry to hear that. How about, Mr. Ron Keel? You were hit by a drunk driver, correct?
Correct.
Anything about that you think, would make this just not be a good case for you to be a juror?
No.
Okay, you can continue to be fair?
Yes.
I appreciate that, sir. Anyone else that maybe now that we've started talking about it, remembered an unpleasant circumstance or something, and maybe this is just not the best case for them? All right, so I have a PowerPoint I want to go through, and I'm going to try to go through it very quickly. What kind of trial is guaranteed? The Sixth Amendment to the United States Constitution says in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. The government cannot unilaterally decide whether an accused is guilty of a crime. The only people that get to make that decision are those that are selected for the jury, not the government. Only the people, and you that have picked the 6 individuals on this jury are the people, and only you have the right to make a decision to take away someone's liberty. The prosecutor represents the state. You that are selected to sit on the jury will represent the people in this case. And during a fair trial, ladies and gentlemen, I believe we have 3 rules to a fair trial. Number 1, the presumption of innocence. Number 2, the burden of proof is always on the state. And number 3, the burden of proof is beyond a reasonable doubt. And I want to take us through each one of those. So let's start with rule number 1, the presumption of innocence. The only allowable constitutional presumption in a DWI case. So let me put you on the spot, Mrs. Clark. What is a presumption?
Assume.
Exactly. It's a required mindset. It's an assumption. It's a required way of thinking. A locked mental disposition and bias for the citizen. The presumption of innocence is also a default decision where you cannot render a guilty verdict unless, sometimes people say until, but until really isn't fair because it implies you in fact will, correct? So unless the government fulfills its responsibility of proof or burden of proof. So let me ask you this. If I was to ask you to... All right, we let you have one free one, and then the next one you have to go to jail. If I was to ask you right now, Mr. Pitzer, if I was to ask you right now, what is your verdict against my client? What would you say?
I ain't heard the evidence. You gotta see what's the evidence.
Exactly. And what would your verdict be though?
I can't say until I see evidence. We ain't going on this.
So what is he right now? He's innocent. And he is not and cannot be proven guilty until you have been satisfied beyond a reasonable doubt that he is in fact guilty. So any individual accused of a crime is innocent until proven guilty. So now let's talk about the presumption of innocence and a juror's responsibility. To seek and positively look for reasons to doubt or hesitate. To be constantly challenging and questioning the government's evidence. The one and only constitutional presumption in a DWI case is that the citizen is innocent unless the government meets its burden and proves beyond a reasonable doubt that they are in fact guilty of each and every element. How long do you think that presumption in this case will last?
Until the government has proved otherwise.
So the entire trial until you as an individual juror have been convinced beyond a reasonable doubt that the state has proven each and every element in the charge. Rule number 2, burden of proof is always on the prosecutor. The government's responsibility to make you feel absolutely certain you have not made a mistake in deciding whether a person should be subject to the worst and most severe consequence of being convicted of a crime and labeled a criminal. The accused does not have to do anything, prove anything, disprove anything, or present any evidence whatsoever. Does anyone here have a problem with that? Some people say, look, I mean, they're going to have their witnesses, and I think you need to, put on a case. I need to hear something from you. I need to see evidence from you. Anyone here that, even though the law does not require, would require the defense to put on any witnesses or any evidence whatsoever? Some people just feel that way. Anybody here feel that way? Anyone here that's going to require of me, in order for you to vote not guilty, produce any evidence, exhibits, witnesses, anything? Anyone here who feels that way, like, look, if I'm going to make a decision this important, I need to hear from both sides. Anybody here feel that way? Rule number 3, the burden of proof is beyond a reasonable doubt. Beyond a reasonable doubt is the government's required measurement of proof to convict a person of a crime. It's not a rush to judgment measurement. This is a mentally and emotionally safe place measurement for you. What reasonable doubt is not, ladies and gentlemen. Let's talk about what it's not. The bottom of this chart, no evidence presented in a case. Your verdict would have to be what? Not guilty. No trace of evidence whatsoever. The second burden is called a scintilla. What would your verdict have to be? Not guilty. Any evidence at all, even the smallest measurable amount of evidence. The third level is reasonable suspicion, what an officer needs in order to pull you over. Not guilty would be your verdict, right? Should be based upon scientific or particular facts or reasons, not based on a hunch or a guess. Probable cause. In order to arrest someone in the state of Texas, you need probable cause. If the government proves their case by probable cause, what would your verdict have to be? Not guilty. Reasonable and trustworthy information that a particular person has committed a particular crime. Preponderance of the evidence. That's what we have in civil cases when you're suing someone over money. If the government satisfies their burden of proof by showing the greater weight of the amount of evidence. So if the scales tip 51% in favor of one side, what would your verdict have to be in this case if the government proves their case by 51%? Not guilty. Clear and convincing. Clear and convincing evidence. That's the burden of proof the state needs in order to take your kids away from you. If the government comes in here and proves their case by clear and convincing evidence, that is a firm belief that the allegations are true, what would your verdict have to be? Not guilty. The final being beyond a doubt that's reasonable. Not just reasonable doubt, beyond a doubt that's reasonable. And if and only if the government proves each and every element beyond a doubt that's reasonable, can you finally convict in a criminal case in Texas. What reasonable doubt is not, ladies and gentlemen, it's not a statement that I don't care. It's not a statement that you don't believe that DWI laws are important or that you want our DWI laws to be enforced. That's not what reasonable doubt is. It's not a congratulations to the accused. It's not congratulations, you won. It's not calling the police liars just because Each and every element in this case has not been proven beyond a reasonable doubt. Does not mean that you're calling the prosecutors liars, their witnesses liars, or anyone else liars. It just means that each and every element you were not satisfied beyond a reasonable doubt. And it's not a message to the community. This is an unusual case, ladies and gentlemen, where you actually have a police officer on trial.
Mr. Crenshaw, you have 5 more minutes.
Thank you, Your Honor. Where does reasonable doubt come from? Comes from the evidence. Comes from lack of evidence. Conflicts in the evidence. Maybe one witness for the state says one thing and another witness for the state says something else. And at the end, you just aren't sure what to believe. It can come from a conflict in the evidence. It comes from the credibility of the witnesses and the credibility of the evidence. Who does reasonable doubt belong to? It belongs to you, the individual juror. This is not a decision where if 5 of you agree and 1 does not, you get to come out and make your verdict. All jurors must be unanimous in their verdict. So if you go back there, juror number 3, Ms. Rocio, if you go back there and you in your heart of hearts believe that the state has failed to meet their burden, but the other 5 believe they have, are you going to be able to stick to your guns and say that you have not had the burden met in your mind and you cannot vote to acquit? I mean, you cannot vote to convict.
That's what I believe.
That's what you believe. And that's what's required here, ladies and gentlemen. Some people think, well, 5 people agree. I don't want to be the odd duck out, so I'm just going to go on and go along with the majority. Can each of you promise and swear to Mr. Buxton, who is on trial here, that you will stick to your guns in this case and you will not be persuaded by the majority just because you want to go along to get along? Anybody have a problem with that? Some people think, well, it's 5 out of 6. That's close enough for me. Let's just go on and get on out there so I can get back to work in my life. Speaking of, I anticipate we will be here in this courtroom until at least Thursday afternoon. Does anyone here have a work or commitment outside of here that you would be unable to come back tomorrow and Thursday? I do not anticipate we will be here Friday. Anybody have that issue? Juror number 12, Ms. Williams?
13.
Oh, I'm sorry. You're actually juror number 9, Ms. Wall, yes.
Changed it, okay. We are short-staffed. We do have a backup plan if I need to stay.
Where's that at?
Baptist Hospital.
Oh, at Baptist?
But we do have a backup plan if I have to stay.
Understood. Would you having to work be weighing on your mind to the point that you wouldn't be able to be fair in this case?
No, I could be fair. Like I said, I'm a worry wart no matter what, because that's just my life. But yeah, I can still be fair.
All right, wonderful. Thank you.
Mr. Crenshaw, you have 2 minutes.
Yes, sir. All right, a fair trial. A fair trial does not require that you treat the citizen and the government the same. Rather, the 3 rules of law actually require jurors to treat the citizen and the government differently. The government has no right to a fair trial. The only person, the 6th Amendment of the Constitution of the United States requires to have a fair trial in this case is Mr. Buxton. Some people want to hear from the defendant, and the law requires that should the defendant not testify in this case, that you cannot use his failure to testify against him. Does anyone here have an opinion about that would be a problem for them? Some people say, look, I need to hear from who's being accused of this, and if he's not going to testify, then I'm sorry, when I go back there, that would be in my mind, and I would be thinking about
Mr. Crenshaw, you have 1 minute.
Anybody here feel that would have a problem with that? Our laws need to be fair and equal, ladies and gentlemen. Since 1973, there have been 141 people in 26 states that have been released from death row. So you all understand how important this is, okay? Does anyone here, because I don't have any time left, does anyone here have anything that now that they've thought about it, think that this is not going to be a good case for them to be a juror on and would like to talk to us after we take a break? Anyone here have a show of hands? Anyone? All right. Thank you all, ladies and gentlemen.
Okay. Ladies and gentlemen of the panel, at this time, we're going to ask that you follow the bailiff out into the hallway. There may be some questions that we need to ask of you individually, and if that's the case, we will call you in the courtroom individually. Does any side have any challenges for cause?
Yes, Your Honor, we have 7, 1, and 6.
Okay, defense. 7, 1, and 6.
And 4, Your Honor.
7, 1, and 4. 7, 1, 6, 4. State, do you have any? Hold on, wait up. We're gonna wait till the court reporter. She moved. Did you get that? That's 7, 1, 6, and 4. He is 7, 1, 6, and 4. They're for the defense, right?
Yes, Your Honor.
The defense, do you have any challenges for cause?
The state was gonna, yeah, 1 and 7.
So we can agree to 1 and 7?
Correct.
Okay. So that just leaves us calling up 6 and 4?
I think on 1, she'd like to at least see if she can rehabilitate her. She
Okay.
wasn't quite clear on.
Okay, so y'all agreeing on 7?
Yes, sir.
Okay. So what we'll do is, 7 is agreed. We don't need to bring 7 in. So there's 1, 6, and 4. Is that correct?
Yes.
Okay. Six. Let's, okay, we're gonna start off with juror 6. Is that Richard Pitzler? Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Yeah, why don't you get Richard Pitzer in? he could stand in the front, right? You can come on up. Yeah, right there. Now this is juror number 6, and your full name is Richard L. Pitzer.
Yes, sir.
How you doing, Mr. Pitzer?
Okay, Your Honor.
That's good. Now, Mr. Pitzer, we brought you in because there was some follow-up questions that state in the defense would like to ask. Okay, Mr. Crenshaw?
Thank you, Judge. Mr. Pitzer, at the end, when I was asking if you would have a problem if the defendant did not testify, and you would use that against him, you seemed like you started to raise your hand.
No, I didn't. I was scratching.
Oh, you're scratching.
I had no problem, and it's his right.
Yes.
You don't want to self-incriminate.
Right,
It's up to him. I got to look at the evidence before I can make the decision.
right. And there could be other reasons why someone wouldn't want to testify, right?
Yeah.
Other than incriminating themselves.
Yeah. I don't get into that. That ain't fair to him.
Understood, understood. And I know you said you used to drive semis. Anything about that?
No.
Would make you?
No, I had never had a problem, never run in DUIs or anything like that.
All right. How about any problem with law enforcement or anything like that?
No.
Okay.
I got family law enforcement, so.
All right, great. That's all I have to.
State, you have it?
Mr. Pitzer, do you believe that you could hear all the evidence in this case and wait until that point before you made a decision as to guilt in this case?
Yes, I do.
You believe you could be fair and objective?
Yes.
Okay, that's all you're on.
Okay, Mr. Pitzer, you can follow the bailiff outside. Thanks a lot.
Sorry about that confusion, sir.
Oh, it's okay. It's okay. It wasn't me. It was actually Mr. Bailey that was mistaken.
The next person is Kelly James.
That's true.
Yeah.
No challenge on German.
Okay, no challenge. Okay.
Weird having
Yes, sir.
Okay, your full name is Kelly Susan James?
Suzanne.
Suzanne James?
Yes.
How you doing, Ms.?
I'm doing great.
That's good. Ms. James, we brought you back in. We just have, the attorneys have some follow-up questions that they would like to ask. Mr. Crenshaw?
Yes, ma'am. I don't know, we talked about this before, and it seemed like maybe some of your answers, I just want to be sure we're both on the same page. You're telling me that in your heart of hearts, if you were picked to be a jury, you could be fair.
Absolutely.
Absolutely. And you are a member of MAN?
My parents were for the year after my wreck back in 1989, early 90, but haven't been since then. So.
Okay. And your injuries and the horrible accident that you were involved in, even though it was a long time ago, I asked earlier if you were the citizen accused, would you want a juror like you? And you are saying in your heart of hearts, under oath, here now, that you would want a juror like you.
I would, because I know I'm a very logical thinker, and when I have parameters, that's the way I operate. Been a math teacher for a long time, so I would, but I can understand why most people wouldn't, because I have been hit by a drunk driver. That probably seems weird, but I also know I'm really logical, and we have parameters set for us, and I have to stay within those parameters as a juror.
Understood. Final question.
Yes.
Do you want to be on this jury?
I kind of do.
I kind of got that vibe too.
And really, when in my accident before, there was no jury or anything like that. And I feel like
What happened? Was he just not prosecuted?
she was, this was like her 7th offense or something, and 3rd with drugs in the car too, but it wasn't the 3 strikes you're out yet. So she was out on bond in 3 hours and $150 fine and like 6 months probation.
And nothing about this trial is you in the back of your mind thinking, I want to see, what's going on with drinking and driving laws today.
No. I do think they are much better today than they were, but we've been given parameters in the jury, and I feel like you tell me what the structure is, I'm going to stay in it.
Understood. That's all the questions I have, Judge.
Ms. Maxey?
It seems like from your answer earlier that your accident when you were in high school almost led to some blessings and some positive things in your life. With your experience and listening to the facts of the case, could you wait till the end and hear all the evidence and make a fair and objective decision?
Absolutely.
Okay, that's all, Your Honor.
Okay, Mr. James, would you be able to follow the law?
Yes, sir.
Okay, I have nothing further. You may just follow the bill.
Okay, thank you.
Just to,
Oh,
just to protect the record, I want to make a challenge, but I'm fairly certain I know what the ruling will be.
oh, he brought, he should, okay, I'll do the ruling after we do her.
Oh, okay.
Okay. Well, for the record, your name is Jolene Ann Lemaire.
Yes, it is.
How you doing, Miss Lemaire?
Just fine, thank you.
That's good, Miss Lemaire. We asked you to come back in. There were some follow-up questions that the lawyers need to ask. Mr. Crenshaw, you may proceed.
Ms. Lemaire, I believe earlier when I was asking you about, you said on the question that you would be unwilling to serve, and then you kind of said, well, you would, but then I asked you kind of pointedly, you know, can you 100% for sure? And you kind of said you want to or you'll try to. And I do appreciate that. And I promise you, I'm not trying to be difficult, but I've got to be sure he gets a jury that's a great jury. And a jury that can be fair and impartial. And so I need to know right now, yes or no, is this DWI trial a trial that you can 100% be fair and put past experiences with drunk drivers and injuries your family members have sustained out of your mind?
I will try very hard to be fair. That's the best I can answer. I mean, experiences that we've had in our lives help us judge, but I'll try to put that aside and judge just on the evidence. Does that help?
Yes, it does.
Okay.
Thank you very much.
Ms. Maxey.
I don't think I have any questions, Your Honor.
Okay. Ms. Lemaire, would you be able to follow the law in this case?
I always follow the law.
Okay.
Now, I have gotten a traffic ticket.
Oh.
But I admit it, I got it.
Yes.
Were you speaking?
I was. That's why I said I admitted I did it.
Okay. Okay, Ms. Lemaire, the attorneys do not have any more questions. At this time, would you please follow the bill? Oh, who else is coming in?
I think
Somebody else is at the door. Who is that? Oh.
Oh, it's Miss Susan.
It's the boss.
Judge.
Okay, let's do this here. Let's go, okay. Go ahead and say what you're gonna say.
I had a challenge for cause on the last year.
On Lemaire, what's the state's position?
The state is in agreement.
Okay. Now,
It was a slow agreement.
now we're going back to Kelly Suzanne James.
Yes. And I made a challenge, but I understand. I don't think I've got there. But
Yeah.
I'm just doing it to protect the record in case there's a complaint later.
Yes, Judge, Ms. James said that she could follow the law and that
Yeah.
she would be fair and impartial.
Okay, yeah, so I'll deny that challenge. So that leaves, so we got causes on 1 and 7. Okay? We gotta give y'all some time to 1 and 7, just, now who's gonna go in the jury room? Somebody gonna go in the jury room to do y'all strikes, and somebody can stand out here if y'all wanna do it like that.
I would ask that the state go in the jury.
Okay, how much time do y'all need?
I think state's already ready.
Yeah.
I believe.
Okay. Let's say, you say
10 minutes.
10 minutes? Okay.
I'll try to go faster.
Okay, we'll be in recess.